On February 21st, 2023, Mr. Elliott was arraigned in Michigan's 33rd District Court on a domestic violence case arising from an alleged January 27th incident. Because the case remained pending, the allegations had not been decided. Elliott was released on bond with GPS monitoring and restrictions designed to protect the alleged victim and prosecution witnesses. Section 765.6b of Michigan law permits GPS monitoring in certain domestic violence cases, but a location becomes a violation only if it breaches an actual bond restriction. On April 4th, Elliott appeared before Judge Michael McNally. His fingerprints were missing, so McNally ordered him to report to the Woodhaven Police Department. Section 764.29 permits that instruction. At approximately 7 o'clock that evening, Omnilink placed Elliott at the police department. A report later read aloud in court said the Tether unit confirmed his location, emailed a detainer, learned he was there for fingerprinting, and referred to a Third Circuit warrant. Elliott was taken into custody. By the time he returned before McNally, he had spent approximately 38 hours in jail over a supposed tether violation, but the report named no condition he had broken and said Elliott was compliant with his curfew. The location that triggered the investigation was the police department McNally ordered him to visit. A GPS record can show where someone went, but not why. Police contact, a detainer, a warrant, and a tether violation are different legal events. McNally must determine whether any valid hold justified Elliott's detention, or whether he was jailed for following the court's own instruction.
Woodhaven.
Yes, I did, Your Honor, because you told me to.
Right.
Yep. And I didn't know I had a tether violation, and they arrested me. And also, I need to pay a ticket
Slow
today.
down. Slow down.
Sorry.
Slow down. Let your lawyer speak.
I see a warrant. I see he was picked up on a warrant while being fingerprinted out of the Third Circuit in Wayne County.
Do you have is there a deputy right there?
Yeah.
Deputy, can you come back up here, please, and state and spell your name for me?
My name is Officer Marquise Rigel, M-A-R-Q-U-I-E-S. Last name Rigel, R-I-D-G-E-L-L.
Thank you. Mr. Elliott was picked up on a tether violation, it says, on the 4th. For the life of me, I cannot figure out what the tether violation is. I read this record, this report here, and it says that he was over there lurking at the police department.
He's being fingerprinted.
I noticed the above subject tracing the location of the Woodhaven Police Department. I contacted Woodhaven Police, did verify subject was there. A detainer was emailed. I was notified the subject was at Woodhaven Police to be fingerprinted. A Third Circuit warrant was found and the subject was put into EMU writ status. So this has nothing to do with him. Him being in custody right now has nothing to do with a tether violation. Is that true or false?
I'll have to look, sir. Hold on.
I don't see any reference in there about a tether violation.
Well, it says it in here. There was. I mean, implicitly they say it, but I don't see where there was one. I didn't order him not to go back to the Woodhaven Police Department. I think he was picked up on another warrant.
There is reason to believe, and I'm going to state it, not my client. And Mr. Elliott, I don't want you to say anything because you haven't pled guilty to anything and you're presumed innocent. I have reason to believe that maybe there was a battery not charged when he was at home. That may be an issue.
Excuse me, Your Honor.
Yes.
According to the system, it says he's here for malicious destruction and 2 counts of domestic violence. Now, about that report or being a violation of his tether, I would have to even read the report myself, sir. I didn't write the report.
Can I speak?
You're just, Elliott, I want to make sure you don't say anything that incriminates you because you haven't pled guilty to anything.
I know I've been told 4 different things that it is. Like, I don't know what I'm
That's fine. What is it that you're being told?
I'm being told from the sheriffs that picked me up from the Woodhaven Police Department, it was a tether violation. Then when I first asked the Woodhaven Police Department, when I first got there, they told me it was a stalking charge. I've never stalked anybody. Then Now it's a malicious destruction of property, which I'm paying off. That's from another case at Woodhaven that I'm paying off. And I need to pay that ticket off today as well, which is another problem for me, but that's beyond the point. So basically, I'm very confused. My tether got it. I know it's a tether violation, but I don't know. I'm sorry, Your Honor. I'm not trying to confuse you.
All right,
either.
slow down. Just relax.
We're all trying to figure it out together.
Take a deep breath.
The confusion in this exchange comes from several different processes being treated as though they prove the same thing. A GPS alert can tell a monitoring officer that a person entered a particular location. It does not by itself explain why the person was there or establish that a bond condition was broken. A police contact simply means there was an interaction with law enforcement. A warrant, if valid and active, can authorize an arrest. And a detainer tells a jail that another authority may have a reason to keep someone in custody. McNally's problem is that the record mentions all four concepts without clearly...
This hearing starts with a serious problem. Elliott has already spent hours in jail over what officials are calling a tether violation. But as the judge examines the paperwork, something does not add up. The GPS system placed Elliott at the Woodhaven Police Department, yet nobody can clearly identify the bond condition he supposedly violated. Then the officer mentions a warrant, a detainer, and another possible case. Suddenly, the hearing becomes less about a simple GPS alert and more about figuring out exactly why this man was arrested. And the deeper the court looks, the more confusing the situation becomes.
Connecting Elliott to a confirmed violation or active hold. An unrelated allegation is also raised, but the judge prevents Elliott from discussing it because it has not been adjudicated. The court now has to test each possible explanation against the records. Elliott's curfew, his other cases, the alleged police contact, and any current warrant that might justify the detention.
Relax.
I did represent him on the one with the malicious destruction of property. It was a vehicle.
Lisa, there is a note here, malicious destruction of property. It says malicious destruction, signs, bills, or notices.
He's
it
on
says
probation.
he has a... To Judge Hessen?
Correct.
Yes, I handled that file.
Was he on, is he in custody on that one? I cannot figure out why this gentleman is in custody.
I have a job.
Mr. Elliott, I'm going to straighten it out for you, sir.
Thank
Okay?
you. I'm really thankful.
He's working 2 jobs. He's stressed because he's going to lose his job.
I just lost my old job because I got locked up.
All right, settle down. I'm going to help you. Okay? Assuming you need the help or assuming you're deserving of the help.
It doesn't look like he's on a tether for Judge Hessen's case, so there should not be a violation for that.
I don't understand this. I just don't understand this. They're saying at approximately 6 p.m., 1900 hours, or 7 p.m., I guess that would be, while monitoring the OmniLink software, I noticed the above subject tracing the location of the Woodhaven Police Department. I contacted Woodhaven and did verify the subject was there. This is a sergeant from the Sheriff's Tether unit. The detainer was emailed and I was notified the subject was at Woodhaven to be fingerprinted. A Third Circuit warrant was found and the subject was put in the EMU writ status. So I don't know what the Third Circuit warrant's on, but that has to be the reason. But I'm just curious as to why they're putting him in front of me on a tether violation when it appears there was none. The subject was in compliance with his curfew at the time of the arrest, unless the tether violation is for violating a law, and that could have happened while he was on bond, and I ordered him not to violate a law. So I'm unclear. Do we have any other indication that this gentleman was picked up on any other case after he was in front of Judge Hessen, actually, for arraignment on February 21 of 23 and up through the present? And I see nothing.
The Wayne
He just
County
has the
site only
DD
shows
and the
two
list.
cases.
Excuse me, Your Honor.
Yes.
Again, this is Officer Rigel again. I just got off the phone with the coordinator, and Officer Carruthers was stating that in the report, it should have said something about him violating due to police contact.
Well, that could, hang on, Mr. Elliott. But nobody's telling us what the police contact is. I don't know what the Third Circuit warrant is. I'm looking at his lien. Now, granted, this one is dated March the 28th, so maybe you need to update that, Lisa. But I don't see anything on here on his criminal history indicating any other charge emanated after the February 21 of 23 incident. So why don't you start by running his lien again, an updated version? I know it's only 8-9 days, but
Can I say something real
maybe
quick?
that.
McNally orders an updated lien search. The Law Enforcement Information Network is Michigan's statewide system for criminal justice information, including records that can help officials determine whether a person is wanted on another matter. By this point, the court has not identified a curfew violation, a new charge, or another confirmed hold. The remaining explanation is the vague phrase police contact, combined with the Tether record placing Elliott inside the Woodhaven Police Department. That location appears suspicious only if one critical piece of context is missing. The attorney wonders aloud whether someone assumed Elliott was at the station because he had been arrested or fingerprinted for a new offence. McNally does not need to speculate about the actual reason Elliott went there. The instruction came from his own courtroom.
I'm sorry?
Can I say something real quick?
Sure.
I'm wondering if they think he was there getting printed on new charges.
Well, that's what that's Mr. Elliott, would you please stop? I ordered him that day, deputy, to go and get printed at Woodhaven Police Department. He hadn't done it previously. I ordered him to go over there and get printed. That's why I was at the Woodhaven Police Department, because on this domestic violence case that I have that has an offense date of January 27 of 23, for which he was arraigned on February 21 of 23, I noticed when he was in court on April the 4th that he had not been printed. So I ordered him to go over there and get printed, and I set this for a bench trial. Then they're talking about on the Tether violation that he was at Woodhaven PD. I think there's been some. I think there's been
a misunderstanding, Your Honor.
Now the judge starts connecting the pieces. Elliott says he has been given completely different explanations for why he was arrested, while the court still cannot find a clear Tether violation. The judge checks the available records and discovers something critical. Elliott appears to have been complying with his curfew, and there is no obvious new case explaining the detention. Then the attorney raises a possibility that officials simply assumed Elliott was at the police station because of some new offense. But that assumption is about to collapse. The judge remembers exactly why Elliott was supposed to be there in the first place.
So do I.
Your Honor, I'm going to ask that.
Do we have any indication that he has any other case pending in Wayne County Circuit Court, Mr. Deputy Marquez?
No, sir, not that I see. None but the current stuff.
Lisa, do you have any indication on anything, including the lien that you're either have run or are running or about to run, that there's any other hold?
No, the lien is printing down there in the courtroom right now. And I looked on the Wayne County site. It only shows these two cases it's held on.
So the problem is somebody had made an assumption, and my father used to tell me what would happen if you made an assumption, and it's not a good one. This guy's been sitting in jail for 2 days. Unless there's a hold, I want him released immediately.
Thank you, Judge.
Okay?
Yes,
No tether?
Well, no, he's still going to have his tether. I still want the tether on him. Wait.
Yes, Judge.
I want the tether on him still with the same tether conditions. And we will send those back if we need to. No contact with Isabella Cavallan or prosecution witnesses, no alcohol, no drugs, no firearms, no dangerous weapons. He's not to be within 2 miles of that individual's residence or place of employment, and he was not to be released until fitted with a GPS tether. So what I would like is...
The location data was accurate. The interpretation attached to it was not supported by the records reviewed in court. Elliott had gone to the police department because McNally ordered him to complete fingerprinting. The hearing found no curfew breach, no identified new charge, and no separate active hold on camera. With the reason for the police contact finally restored, the supposed tether violation could no longer explain the detention. But the release order does not resolve the underlying domestic violence allegations, and it is not an acquittal. McNally keeps Elliott's existing bond conditions in place, including GPS monitoring and the restrictions already imposed in the pending case. The correction is narrower. End this unexplained detention, reinstall the tether quickly, and continue the case under the existing conditions. McNally then turns from the legal decision to the human cost of the mistake.
Do you still have the tether right now, Mr. Elliott?
No, they cut it off, Your Honor.
So they need to get that back on him with those same conditions. And would you tell them the judge would really appreciate it if they would expedite it, since he's just spent 48 hours in jail, or if thereabouts 38 hours in jail that he shouldn't have spent 38 seconds on?
Yes, Your Honor, I'll get with my sergeant ASAP.
So Lisa, let's send that back. The minimus, we'll just do an amendment and say the defendant has posted bond, because he has, February 28th of 23. I'll just make a note, and then you can put in the conditions to make sure they get all the conditions in here. Defendant taken into custody on April the 4th. It appears that was in error. Defendant to be released immediately, but I need you to have those. But this is not right. Look, they got to be more careful down there. I mean, this guy now, he spent 38 hours in jail. I wouldn't want to spend 38 seconds in jail, let alone 38 hours. Now, he's got himself into trouble, but he still enjoys a presumption of innocence here. And now somebody's going to tell me they can't get the tether back on for a day or 2 or 6, and that isn't right either. So do whatever you got to do. Tell him the judge said he wants this guy fitted with the tether first and foremost right now, as soon as possible, so he can get out of there, because he should not have been in custody for the last 38 hours, as far as I can tell.
Thank you, Judge.
I'm going to give my sergeant a call right now.
And if they need to talk to me, they can call the court and I'll talk to them. But you got to be careful. Thank you very much, Deputy. Have a good day.
Thank you, Judge.
Thank you, Mr. Baldwin.
Thank you, Your Honor.
Thanks a lot, Mr. Elliott. Stay out of trouble, though.
I will, man. I'll talk to you.
I don't want you to say a word. Stay out of trouble. Don't say a word.
The public hearing does not establish who first entered the detainer or exactly where the misunderstanding began. It also does not prove that any officer intentionally targeted Elliott. What the record shows is a chain of assumptions that survived until the court compared the location alert with the reason for the location. Elliott was at the police department. The missing fact was that the judge had directed him there. McNally ordered Elliott released unless another hold existed and required the GPS monitor to be restored under the same conditions. The available video does not verify the exact moment he physically left the jail, and it does not establish the later outcome of the pending criminal cases. This hearing demonstrates why a precise data point is not the same as a complete explanation. Monitoring systems can report where someone went. Courts and law enforcement agencies still have to verify why that person was there before a label in a file costs someone their freedom. For Elliott, that verification came approximately 38 hours late. Which part of this process should have caught the mistake first? Let us know below and subscribe for more courtroom cases examined through the record.
This is where the entire situation changes. The judge confirms that he personally ordered Elliott to go to the Woodhaven Police Department for fingerprinting. That means the GPS location that triggered the investigation was not evidence of wrongdoing at all. It was the exact location Elliott was instructed to visit. After reviewing the records, the judge finds no confirmed tether violation or separate hold that explains the detention and orders Elliott released. But he also keeps the existing bond conditions in place and demands that the GPS tether be restored immediately. Then comes the judge's strongest warning. The system has to be more careful because Elliott spent roughly 38 hours in jail that he should never have spent there. If you enjoyed this courtroom breakdown, don't forget to like, subscribe, and turn on notifications. We'll see you in the next video.